Loyalty. My name is Oluwatosin Isaac, and today we'll be talking about tenancy agreements and some of the clauses we find in a tenancy agreement. Now, we know that for every transaction or any contract between two or more persons, it is usually advisable that there is an agreement that is binding parties together. Okay, fine, you might say, okay, based on familiarity and the fact that, okay, this person is well known to me, you might decide, okay, we'll just agree orally. Oral agreements stand, but it's usually advisable you put it on ink and paper, you understand? You put your pen to the paper and draft out agreements, clauses that will bind both parties. Okay, so today we are narrowing it down to tenancy agreements. I don't really need to say much, but from the word tenancy, you say that tenancy from the word tenant, and when you get a tenant, it means there's a landlord, and when there's a landlord and a tenant, then it means there is a property involved and somebody wants to rent the property or lease the property, and one person is the owner, another person is renting it, and you understand, like there should be an agreement binding. Okay, I'm coming to you, I'm in love with your property, I want to lease, I want to rent it, like I need it for a certain number of years or a particular period of time. How much will you lease it out to me? So landlord tenancy. So when we have a tenancy agreement, is just that document, that's agreement that binds both a landlord and a tenant. So it just establishes what parties will provide and receive from each other, stating your obligations, what is expected of you, what you're supposed to do, like that. So like I said, there are sometimes most people just make this oral agreement orally. Okay, you have to pay this, you have to pay this. So if there is no tenancy agreement, it does not really it does not mean that the landlord does not have rights or the tenant does not have rights. You understand? No, there are some houses, there are some properties that are being rented out, leased out, and we don't have a written agreement. It's just already, okay, your rent is 200,000 per annum. You have to pay for this, you have to pay for this, you have to pay for this. This is what we do. They just list out the rules. Okay, fine. Tenants, okay, I've heard you. Understand? And the tenant is already in the property, occupying the property, like that. So it doesn't mean that the fact that there is no written agreement or there is no written contract between the landlord and the tenant does not mean that both the landlord does not have his rights or the tenant does not have his rights. But like we do say, it is advisable you draft an agreement that binds both parties. And you know, there are some times when you see agreements like that, most people will say, oh, this grammar is too much, I don't understand, what does this mean, what does this mean, what does this mean? So sometimes if you know you don't really understand the words, or you read it as a tenant and you feel that, okay, this agreement, the contents are not straightforward, you can employ the services of a lawyer to review the agreement for you, because there are some clauses that might not really be favorable to you, and to avoid any future disputes or contention, it is better you review it before signing it and occupying the property. So today we are looking at the clauses, some of the clauses we see in a tenancy agreement and their meaning, or the implication rather, like that. So the first is the date. Definitely every agreement should have a date. Any document or any official document that is not dated is deemed to be invalid. I mean, you can't have a document, it's not signed, it's not dated, it's just like a mere paper. So for the tenancy agreement, you find the date at the beginning of the agreement. Here you see this tenancy agreement is made this dash day of dash day. So that date is that date specifies the day the agreement was made. Okay, we drafted it, we made this agreement this day. But however, there is another date that is usually contained in the tenancy agreement. You know, it is the tenancy agreement. So you are coming to lease, a landlord is leasing his property. Lease is not permanent, right? It's just for a particular period of time. So that date included in the body of the agreement will contain the tenancy period. Okay, from this period to this period, this is the date you are occupying the property. So like that is just another date there. But so I said here that there are two dates in a tenancy agreement: the date when the agreement is made and signed, and the date of the tenancy period, but ensure that, of course, in a tenancy period, in a tenancy agreement, you should specify the days. My tenancy is between this period and this period, this period and this period. In fact, the landlord will ensure that it is duly stated, so that when your tenancy has been determined, or your rent is due in the layman term, you can have every right to come and knock your door. So that is that with the dates. Then of course we have parties. There can't be an agreement without parties. They have to be the parties. So we have the landlord and we have the tenant, or tenants as the case may be. So for the parties, to identify the parties, the proper and the right way for you to be drafted is that the full names of the parties and their addresses. That is the right way to identify a person in a document. So person of, then his address where he stays, a full address where he stays. So you also find that in the tenancy agreement. They also find the background. The background is a clause that explains the details of the property, title of the property, who is the owner of the property. Okay, this person is the owner of the property and he has agreed to lease it out to so and so for a certain period of time, for so years, for so months. You understand? So that background will state like the details of what is going on. Why are you guys coming together? Why are you coming together to form the contract? Oh, the landlord so has agreed that he wants to lease out the property situate at this to this person, and this person has agreed to fulfill every obligation or every necessary steps required. So that is just the background. It's just giving you the background of what the agreement is all about. Who owns the property? Who is leasing it out? When does it plan to lease it out? When will the tenancy expire? Everything, just like a brief summary of the property and the owner and their rights to lease and to pay for it. So after that, we have the consideration clause. The consideration clause is the clause that specifies the amount. It specifies the amount. It states the amount to be paid and also how it should be paid. You know, there are sometimes some persons might not be able to afford the whole rent. Some persons might pay the whole rent. Okay, the consideration of the sum of, like we've agreed that he's going to pay 200,000 naira per annum. However, he has agreed that he will pay 70%, then pay the 30%, or you pay full amount, then subsequently you pay. You understand? Just the terms and conditions of payment. So the consideration clause is just all about the money, all the money involved. Okay, by so time he's going to pay, so time he's going to pay in installments, he's going to pay after 6 months, he's going to pay after 4 years, he's going to pay after. Just the specification of how the money is to be paid. So we also have, then we have the covenants. The covenants are the obligation. We have in a situation like the landlord covenant to, or the landlord has agreed to provide, to pay, to ensure. You understand? So everything the landlord is obligated to do, it is listed out. It is listed out. And likewise for the tenants, the tenant agrees that he will ensure that the house is in reasonable wear and tear. It doesn't destroy the properties. He uses it for the purpose in which it was rented for, probably residential or commercial. The tenant agrees to pay his rent. The tenant agrees to live peacefully. The tenant agrees, you understand? So all the obligation of the tenant also, including that of the landlord, is also contained there. So, but in this place, the both parties are definitely in a tenancy agreement. It is the lawyer to the landlord. It is the landlord that prepares the tenancy agreement. So it's usually advisable that the tenant takes a proper and detailed look at it before signing, because in the covenant of the tenant's covenant, I say the tenant agrees to. There are some clauses there that might not be favorable to you as a tenant. So this is when you are supposed to have a very detailed look, be very thorough when it comes to that. Let me see, what am I covenanting? What am I agreeing to do? Okay, I will pay my rent, definitely. I will ensure peaceful possession, of course. I'm using it for residential purposes. That's why I rented it. I'm going to pay. You know, when you start seeing payments, you pay this, you pay this, you pay this, and like, what am I paying for? Okay, am I supposed to pay for it? You understand? So that's where you seek the guidance of a lawyer to put you through. So tenants are usually advised to go through the covenant clauses very well to see that they don't shoot themselves in the leg and sign an agreement that they might not be able to fulfill in the future. Then also we have a very important clause, which is the rent renewal clause. Now, a landlord can decide to increase his rent. He can decide to renew it and say, okay, fine, you paid 200 last year, but right now the rent, or you paid 200 when I was leasing it out to you, but because of the inflation, because of the economy, because of the price of things, okay, and now your rent is 250. But fine, the fact that a landlord has the right to renew does not mean he can arbitrarily just do it, just wake up one morning and do it. Some people, if you give them that privilege, they can be increasing your rent every year, which is not right in the real sense. So this rent renewal clause is a clause stating that in the event that the landlord wants to renew his rent, he will inform the tenants, or probably, okay, fine, he will inform the tenants, and this is how he's going to renew it every 3 years, every 2 years. You understand? It will be stated there, okay, at the end of 2 years there will be a renewal, at the end of 3 years there will be a renewal, at the end of 4 years there will be a renewal. So the tenant is aware that, okay, at the end, after 2 years, after 3 years, there's every probability that I will be paying an increased sum. So a renewal of rent does not apply to a subsisting tenancy if the tenancy, or if the clause is not stated there. If there is no rent renewal clause, a clause stating that, okay, every 3 years the rent is subject to renewal every 3 years, or the rent is subject to renewal every 5 years. The clause has to be stated there. If not, there are some landlords that will just go away and just keep increasing the rent. You see, we've heard of stories where a tenant rented an apartment this year, and it's not up to 1 year, or even after 1 year, the landlord is already increasing the rent again. Understand? So it's to avoid things like this. But if there was a rent renewal clause, of course that cannot even stand. You understand? Like, okay, you've agreed that it's after 3 years, so why are you increasing your rent? You have every right to contend that. So very important, the rent renewal clause. And also we have indemnity clause, that, okay, in the case that so person breaches the agreement, that person will indemnify, or probably will settle it in the courts or something like that. Just in the case of disputes, we are going to have settle our disputes in the courts, or we are going to take this court, or we resort to alternative dispute resolution like that. So, but the most important thing to note is that when a tenant is renting a property, or when a landlord wants to lease a property to someone, you ensure that you go through the clauses thoroughly. You go through the clauses dutifully and check every clause and every word, because sometimes it might just be just one word. One word can have a very serious implication and might not be favorable to you. So a tenant must understand the implication of every clause that is written in an agreement, must understand it. And most people, because they don't want to pay lawyers fee, we have to pay lawyer, most people run from paying lawyers fee, and they end up shooting themselves in the leg, and it's become disastrous for them at the end. And the lawyers fee that they were avoiding, they eventually pay it, because they need a lawyer to represent them in court. So instead of wasting resources, wasting time, why not do the needful from the beginning? You employ a lawyer, employ the service of a lawyer to review your agreement before you sign it. So we've come to the end of today's session. Thank you for joining us. Thank you for following through. If you have any questions, you can drop your questions, drop your contribution, drop your comment. If you have any experience, there are so many stories of landlord-tenant experiences. So if you have experiences, you can drop them and you can share. Probably you need clarification or something, you can just drop them and we will reply to them. Don't forget to follow us. Don't forget to like our page and share to as many people as possible that you know who needs this knowledge. Everybody needs knowledge. So share it to as many people as possible. Thank you for joining. Till same time next week, we will bring you another topic. I hope you've learned something. My name is Isaac, and I will see you next week.